Joe Bowser from Roth Jackson, here for another edition of Readymode's video series on TCPA compliance issues. This video, we're going to talk about questions to ask lead generators about their compliance with applicable laws. Now, if a lead generator is using TCPA regulated technology, like phone calls or text messages, you're going to want to ask them about their own TCPA compliance. But the lead generator themselves, if they're not using those technologies and they're just, for example, securing consumer consent for you to call or text them via the web or other experiences out in the world, then they'll have data broker, state privacy law requirements that apply to their business, but the TCPA burdens will essentially be on you because you're going to be the ones using the phone or text message to communicate with those leads that you buy from the third-party lead generator. So I have had many experiences over the years where someone comes in and says, I bought scrubbed data or I bought opt-in data. And that sounds amazing. The problem is there are a lot more questions to ask just because somebody tells you that they're selling scrubbed data or opt-in data. Remember, opt-ins are personal to the company who got the opt-in. It's like a kiss, right? The man or the woman consents to kiss you and not anybody else. So same with opt-ins in the TCPA space. You can't just transfer them by buying them or otherwise. So one of the first questions you want to ask is, how are you getting consumer consent? Typically, it's on a web form, a social media form, something like that. So if that consent is going to be of any use to you, your name needs to be on it. So you need to see the form of that consumer opt-in page, look at the flow. It matters a lot how clear and conspicuous the terms are. If the consent to call or text is buried in a terms and conditions page and it's effectively a browser app agreement, that has a very different legal character than something that's clearly and conspicuously giving you, the buyer of the lead, the right to do what you're gonna do with it. So one of the other things you want to do is ask yourself, how am I going to use this lead? Am I going to make pre-recorded calls or AI calls with them? Am I just going to use live agent? Are they going to be marketing calls? Am I going to send SMS, for example? You want to make sure that you're getting the consumer's consent to do those things that you're going to do. So if you want to fax them, for example, FAX, you should get permission to do that. So you want to get clean eyes on the web opt-in or whatever other mechanism they're using to secure consumer consent. Look at the flow, get them contractually agree in the insertion order or whatever the contract is that you're agreeing to, that they need to show you what it looks like up front. And if they make any type of material change, they need your prior express written permission to make any changes. One of the other considerations you want to look at is it you and 50,000 of your competitors that are on that web opt-in? Some courts are starting to question the extent to which those types of agreements can be clear and conspicuous. Now, for those that are in the space, they'll know that the FCC's one-to-one consent rule was declared unlawful by the 11th Circuit Court of Appeals in early 2025. So it's not an FCC rule per se, but after Supreme Court decisions like Loper-Bright and McLaughlin, the federal district courts now have a greater police power over interpreting and applying the TCPA than it did. So just because the FCC's one-to-one consent rule was declared unlawful doesn't mean that there aren't other ways for plaintiffs' lawyers to attack a given opt-in. So think about lead generation. If you've ever had a little kid, everybody is super careful what they feed their new baby. Think about your lead generators like that. Whatever you're putting in your baby's body, you want to think about the lead generators, the quality of their product the same way. You're gonna go all organic, you're gonna read the labels, you're gonna look under the hood and make sure that this is something that you wanna put into your business, because this is sitting at the top of the funnel. And if you put garbage in, you get garbage out. So you wanna make sure that you're getting treasure in so that you get treasure out, because again, this is the top of your sales funnel. And even folks who use inbound calls from a lead generator, you still need to ask them, where did they get that inbound call? If they were using unlawful techniques to secure the inbound call, or they made an outbound call that was not lawful and then they transferred it to you, they're going to hear your name. They may not even hear the lead generator's name. So you're the only name that the consumer hears, and that's probably who they're going to sue. And they'll just assume, and the courts may indulge the assumption, that your lead generator was acting in an agency capacity for your benefit. And while you may win the case on vicarious liability grounds, down the road, you're defending a lawsuit. They're time-consuming, distracting, and expensive. So do your homework up front. Ask your lead generators to prove contractually exactly how they're getting leads that you're going to buy. Make sure that they are drafted in a way that's clear and conspicuous. The flow is transparent. If you worked backwards from a problem, you could show the judge easily that this was a clear and conspicuous opt-in from the consumer. They agreed to the type of communication that you ultimately communicated with the consumer with, and the judge will agree with us that it was an entirely valid opt-in. You also want to consider whether the lead generator is including arbitration clauses and class action waiver clauses. If they are, those also need to be clear and conspicuous, and you ideally get click-wrap agreements to bind the consumer to those arbitration agreements, which are generally enforceable as long as they're done correctly. So again, if you just hear this is opt-in data or this is scrub data, probably red flags. There are so many more questions that you need to ask if somebody is just peddling opt-in data or scrub data. Scrubbed for what? Scrubbed for the national DNC, the state DNC, litigator scrubs, wireless scrubs. So if you don't know what they're scrubbing for, you can't even assess your risk, because how you're using the data affects what scrubs need to be done. If you're not making telephone solicitations, maybe you don't need the national DNC scrubbed. And oh, by the way, if they are scrubbing for the national DNC, it should be your SAN or someone who's making calls on your behalf's SAN. So you want to ask those sorts of questions, because I've had folks buy allegedly scrubbed data thinking it's the DNC scrub, and leaving aside the challenges with third-party scrubbing, it turns out it was litigator scrubs. Well, that's prophylactically helpful, but it certainly is not the same thing as the National Do Not Call Registry that you need to scrub for every 30 days. If you're making sales calls to strangers without an established business relationship or consent. So again, I like to remind clients that, think about it. If you're a bodybuilder eating clean, or, a new parent feeding your child, you want your leads to be clean, well vetted, and appropriate to your use case. So that's how I like to think about working with lead generators. Make sure that you have an agreement that makes them stand behind the risks. Now, indemnification clauses are only as good as their financial wherewithal, but it will help level set the expectations between you and the lead generator about what you expect to happen and require to happen under the agreement. And nobody ever wants to sue a lead generator, but at least if you have a well-crafted contract that lays out the rights and responsibilities of the parties, it can help in your defenses, and it can also help make sure that you're only working with lead generators who are serving you leads that you actually want to buy and use. So that is a quick recap of the types of questions and considerations that you want to undertake when you're working with third-party lead generators for your outbound calling and texting campaigns, and even inbound calling if you're getting inbound calls from a lead generator. So I hope that was helpful. Again, Joe Bowser from Roth Jackson. I've been practicing TCPA for over 2 decades now. So this is certainly something that comes up with great regularity for folks that don't do first-party lead generation themselves. So keep those things in mind, and keep fighting the good fight. Thanks for your time.